Hello, everyone. My name is Scott Tate. I'm President and CEO of the Greater St. Charles County Chamber of Commerce. I want to thank you for joining us for our business education series, Chamber University. In today's discussion, we'll be talking about Missouri employers and medical marijuana and what you need to know. But before we bring in our speakers, we want to give our sponsor an opportunity to say a few words. So today we have Kiva Jet Ricketts from the Villages of St. Peter's Memory Care, our sponsor. So Kiva, we'll let you take a few minutes to say a few things about Villages of St. Peter's.
Thanks, Scott. Good afternoon, everyone. Again, sorry I don't have a camera. So as many of you know, we're an assisted living memory care. We're devoted to those folks living with some form of dementia. So we're there just to help with any activities of daily living that they need, whether that be taking a shower or eating lunch. We're here to help for that. We also do have respite care available. So if you know somebody that's caring for someone with dementia or Alzheimer's and they need to go on a vacation or just need a break, then the loved one can stay there for a few days at a time and we'll take care of them. The big thing I do want to say is now we are actually open and I am scheduling in-person tours. So we're fortunate in the way that our building is set up that I can tour folks in person on the side of the building that doesn't have any neighbors, which is what we call the folks that live in our community. There's a side of the building that doesn't have any neighbors on it. So I am scheduling in-person tours. If you know anybody that's interested, just have them give me a call. We'll go through all the safety precautions, masks, hand sanitizers, and I can show them the community. Thank you.
Perfect. Well, thank you very much, Kiva, for your ongoing support of the Chamber and your support of this program. We really appreciate it. Moving on, today we have two speakers again. We had them last month. We have Katherine Flett and Ruth from Danna McKitrick. And I'm just going to turn the program over to them and let them talk about themselves, introduce themselves and their background, and then go right into their presentations. So I guess I'll turn it over to Ruth first, or Katherine. Who wants it?
Katherine has it.
I'll take it. So the title of this presentation is An Employer's Guide to Medical Marijuana in Missouri. This was a hot topic before COVID, and admittedly, COVID has paused just about everything, including a lot of things to deal with this topic, but we expect for this to ramp right back up when everything else does. So it's still relevant here, and I'm just gonna go to the next slide here. I am a member of the litigation team at Danna McKitrick, and I focus on assisting clients with insurance-related business or civil litigation matters. I'm also a member of the employment law team. I'm going to go over to Ruth now, let her introduce herself. We are going to do this is about 3 separate sections, and after each section, we will stop for questions. If you want to type your questions as you think of them, just so you don't forget them, go ahead. And after each section, we'll kind of take a little break for those and answer them as best we can. All right, Ruth, take it away.
Hi, everyone. My name is Ruth, and I have the transactional practice. My specialties are corporate law, employment law, and some intellectual property and copyright and trademark. I work a lot with small businesses and have done that for 25 years or so. So we'll go on to the topic. Okay, so legalization of medical marijuana in Missouri is different from pretty much all the other states in that we actually did a constitutional amendment. Most of the states have passed statutes. That would never have happened in Missouri because of the Republican legislature and Governor Parsons. It would never have been voted on. So the investors who are investing in this, because they think it's a good idea, went the constitutional route. So we actually amended our Missouri Constitution to allow medical marijuana. And Kate and I have not found one case where another state did the same thing. And that makes us very different and the law very different. So 66% of the Missouri voters approved Amendment 2. So For those who don't know, constitutional amendments or the Constitution of Missouri would trump state statutes. So now registered patients and their caregivers are allowed to purchase up to 4 ounces of marijuana from dispensaries every month. Now, it's not that easy to become a registered patient. You have to apply to the Missouri Department of Health and Senior Services and submit a physician certification. Most of those physician certifications cost about $150. Once approved, you get an ID number, you get a card, and it's good for 1 year. So that's important to know that those cards are only good for 1 year. The process is relatively easy. There's a 4% retail tax applied to sales, and the new law also allows you to cultivate 6 marijuana plants per patient registered with the program. Okay, next slide. Next slide. Okay, so the physician just is not going to approve this for everyone. Remember, this is medical marijuana. So the reasons, the qualifying conditions for it are listed there, and they make sense under the Missouri Human Rights Act or the Americans with Disabilities Act, because it's what you would consider a disability: Alzheimer's, cancer, epilepsy, glaucoma, AIDS, PSD, psychiatric disorders. There is one catch-all provision that says that the physician can recommend cannabis for any chronic, debilitating, or other condition they see fit. And that sort of tracks the ADA also. So it's the physician has to buy into the fact that you have a disability. Now, there have been some newspaper articles where there's been some shams, people have been getting false physician certifications, etc. But with every law, there's going to be some game playing, and I do think that people are jumping on it. So next slide. Okay, so you can see that a lot of people have been approved. 50,000 patients were approved as of July 2020, and 2,000 caregivers were approved on behalf of the patients. 15,000 cultivators were approved. And you can see there's some denials outright. We have no idea why they were denied. And then some were rejected because they needed additional information. So going on to the next slide. Okay. So very quickly, the effective date was December 2nd, 2018. I'm going to just say DHSS, the Department of Health and Human Services, published draft rules. Then in May, they published the final emergency rules. In August of last year, the facility applications began to be accepted. December 2019, January 2020, there were facility license winners. And of course, there's always a lot of issues with that. And then July 2020, the first dispensaries this month were scheduled to open in Missouri, but COVID-19 has delayed that. So going on to the next slide. There were 2 things that happened with the Missouri legislature that Governor Parsons signed. One was an amendment to the state's telehealth statute, and that it allowed physician certifications of medical cannabis patients, and thus enabling doctors to virtually interview patients. And this was because it was hard to see a doctor, and a lot of hospitals, the fear was that they were going to be so busy with COVID-19, they wouldn't be able to see patients. There was a lot of talk about how cannabis is edible, and if it's cute, just like the Jewel, it was very cute and appealed to young people, whether or not all of that should be disallowed. But now they restricted it, but they do allow some marijuana edibles for the manufacturers of marijuana to sell at dispensaries. And that was signed on July 13th, 2020. Next slide. So this is a tricky area because under the Controlled Substance Act, possession, purchasing, and selling marijuana is illegal in the eyes of the federal law. So under the scheduling system, the federal government classifies marijuana as a Schedule I drug. So that means it's worse than heroin and cocaine. So they see no medical, basically it says there's no medical value whatsoever to marijuana. there is an amendment, so the Department of Justice won't go after the state, which is the Broadback Amendment, and it prohibits the Department of Justice from spending funds to interfere with the implementation of state medical cannabis laws. So there were, prohibition was a time where everybody wanted to go in and after it stopped and make a lot of money. Anheuser-Busch has got a lot of history in the prohibition area. Marijuana is considered one of those areas where you can make a lot of money. If you try to change the federal law and just allowed people to get it with medical practitioners, then the fear was pharma would take it over. If you said it was totally legal, then the fear was the big cigarette companies would take it over because they have the distribution outlets. So basically now what's happening is every state has different laws. Illinois there's no law against using marijuana. You can use it for medical and non-medical purposes. So it really is dependent upon what state you're in as to what rights the employer has and what rights the employee has. Okay, next slide.
This is where I pick up. Does anyone have any questions for Ruth section before I start in? Did you have any questions, Scott?
There is a question here from someone here. I'll bring it up on the screen here. It says, I've had a lot of skin cancer issues, melanoma type of cancer, and maybe this isn't an appropriate time to ask it, but I'll throw it up there anyway. If you think it's more appropriate to bring up later, address later, then bring it up then. So, but he's got the kind that can kill you. Would he qualify to get some marijuana, or is there certain cancer diagnosis that would qualify more than others?
Okay, so with that kind of a disability, if he probably could go to his doctor and get the doctor to fill out a certification. Because cancer is a disability, it's considered a disability under ADA and Missouri Human Rights. So yes, he probably could get a certification. And once he got a physician certification, you will see on an earlier slide that he can get on a website and apply. So then it would be up to the Missouri Department of Health and Human Services. Okay.
And there's also that catch-all provision that Ruth mentioned that we're unsure, every physician may apply that a little differently. Some of them may be stricter on it than others, but that catch-all provision will be interesting to see, what types of different conditions might fall into that.
Yes.
Okay. Yes. Good.
Any other questions?
Any other questions? All right. Well, just as a reminder, post it in the comment or in the chat in YouTube, and we'll try to bring them up after each section. So I guess next we'll move right back into Katherine. So Katherine, I'll let you take it over.
Great. So great. So as Ruth mentioned, Missouri has a constitutional amendment, and that's very unique to our state. Because other states, what they have done is they have passed a separate statute with regard to medical marijuana or marijuana use. And it's going to differ. We don't have any case law in Missouri yet. We don't know how Missouri courts are going to handle this. But like Ruth said, the Constitution trumps statutes. So we have, in Missouri, the Missouri Human Rights Act that prohibits certain, disability discrimination, that kind of thing. It'll be interesting to see how courts will apply this constitutional amendment and these other state laws. But just to take a look at some other states and see what they have done, I'm going to start here with a case called Suave or Safeway. In all of these cases, it's important to remember that these outcomes depend on the court, the terms of the statute, the facts, and the legal arguments made. But this case was a Washington case in 2015, and there the employer had a drug-free workplace policy which prohibited testing positive for a controlled substance on the job or on company premises. So that's similar than most of us probably have similar policies in place. In that case, the employee tested positive for marijuana, and that was as a result of his after-hours use pursuant to a valid medical marijuana card, and he was terminated. He sued, asserting claims for employment discrimination on the basis of disability under the Washington Law Against Discrimination. So that's kind of the equivalent of the Missouri Human Rights Act. And there, the court ruled for the employer, holding that the Washington law does not require the employers to accommodate the use of medical marijuana where they have a drug-free workplace policy, even if medical marijuana is being used for the employee's disability. So that's Washington 2015. Let's see what other states have done. This next case, Noffsinger versus SSC Niantic Operating Company, it's a 2017 case out of Connecticut. And there you're dealing with a prospective employee who he was diagnosed with PTSD, and he was a qualifying patient under the Connecticut's Marijuana Act. He brought a discrimination act after he was denied employment by a prospective employer based on a positive cannabis result during a pre-employment screening test. And the court in that case held that a private cause of action existed to enforce the anti-discrimination provision protecting employees from discharge on the basis of his qualifying patient status. So again, in that case, the Connecticut's Marijuana Act had a specific provision stating that you could not discriminate, in the employment setting based on someone who had their medical marijuana card. And the court upheld that and said, yeah, a private action, cause of action does exist here. You can sue. All right, next we have, this is a case out of Arizona in 2019, Whitmire versus Walmart stores. This one was in the news. I remember hearing about this. Here, the employee was terminated after a positive drug test, like the other cases, and he sued the employer alleging wrongful termination under the Arizona Medical Marijuana Act. And that's the statute in Arizona that allows for medical marijuana. Their statute included, again, this anti-discrimination provision, which essentially provided the employer can't discriminate against a person hiring, termination, any condition of employment based on a positive drug test for marijuana unless they can prove the patient used, possessed, or was impaired by marijuana on the premises of the place of employment. And in that case, the employer moved for summary judgment. Summary judgment is basically a mechanism to put the case away early on. So it's not trial. The judge will decide based on the law and the facts. There's no facts in dispute. And based on the laws that I'm looking at here, he'll dispose of the case one way or another without even getting to a jury or going through the trial process. And there, the employer moved for that, the summary judgment, based on its drug-free workplace policy, kind of similar to that first case we were talking about. And the court granted a non-filed cross motion for summary judgment for plaintiff. So plaintiff didn't even file a motion for summary judgment, but the courts are allowed to what's called sua sponte. They can, on their own, create their own motions on behalf of a party. And the court found that the statute did not include an exception for drug-free workplace policies. So there, unlike that first case that we talked about, where the court says, this employer has this drug-free workplace policy, here they're saying this statute has a specific anti-discrimination provision, and there's no exception for these drug-free work policies. So that's kind of an interesting result there. Last case I have here, I won't bore you guys too much. This is a New Jersey case, and it's from this year, Wild versus Carriage Funeral Holdings. And there, the employee was terminated after a positive drug test and sued the employer under the New Jersey law against discrimination, which is, again, like our Missouri Human Rights Act. And that was on the basis that he had a disability, he had cancer in this case, and he was legally treating that disability in accordance with the medical marijuana law in New Jersey. And the court there held that medical marijuana patients can sue their employers for disability discrimination and failure to reasonably accommodate the need for medical marijuana under the New Jersey law against discrimination. So as you can see, there's kind of a trend here. We started back in 2015 with that case where the court came out, on the employer's side. And it seems like there's this trend that the more recent cases are really siding with the employees. But it really it's going to depend on the language of the statute, the arguments made, and the courts involved. So what are some considerations for Missouri employers? Some of your employees probably already have DHS ID cards, and they're probably already legally consuming medical marijuana. It's probably not a shocker to you employers, but there is nothing in Amendment 2 that says qualifying patients have to purchase, possess, or consume products from a Missouri licensed dispensary. So just because there's no Missouri dispensaries open quite yet due to COVID doesn't mean that your employees aren't already getting it. First of all, they can grow their own, or they can obtain products from other states. Illinois has 37 licensed medical marijuana dispensaries. I know there's one over in Belleville that's, that you can get recreationally. Amendment 2 does include some exceptions. So this is where it's important for your employers to take note of these exceptions. This does provide some guidance to employers, but it really leaves a lot to be decided by the courts, because it's going to depend how the wording of these statutes is going to be applied to specific situations. The first exception is that nothing in this section permits a person to consume marijuana for medical use in a jail or correctional facility. Second is to undertake any task under the influence of marijuana when doing so would constitute negligence or professional malpractice. Third one is to operate, navigate, or be in actual physical contact of any dangerous device or motor vehicle, aircraft, or motorboat while under the influence of marijuana. This last exception is the one that will apply most to employers here. It does not permit a person to bring a claim against any employer, former employer, or prospective employer for wrongful discharge, discrimination, or any similar cause of action or remedy based on the employer, former employer, or prospective employer, prohibiting the employee, former employee, or prospective employee from being under the influence of marijuana while at work, or disciplining the employee or former employee up to and including termination from employment for working or attempting to work while under the influence of marijuana. That's a mouthful. It comes down to employees can't sue their employers for prohibiting them from being under the influence of marijuana while at work. Well, that's tricky. Under the influence. How do you prove who is under the influence? It's not like alcohol. There's not just this simple breathalyzer test. What does under the influence of marijuana mean? Like I said, there's no reliable test available yet to scientifically confirm whether someone is currently under the influence of marijuana. Science hasn't quite caught up to us yet. I know that they're working on that test. There's been a bunch of stuff in the news, at least before COVID there was, about certain tests that police might be able to administer to determine DUI or things like that. But simply there just isn't anything like that today that can be quick and available. So just because an employee tests positive for marijuana on a drug test does not mean that he or she was under the influence while at work. How long a person will test positive for marijuana depends on a lot of different factors. And that includes how frequently the person consumes marijuana, how much marijuana the person consumes, the person's amount of body fat, that's because the THC is stored in fat cells, so that does matter here, and the sensitivity of the drug test. Studies have shown that it can stay in a person's system for 25 days or more from the last date of consumption. So your employee could be using medical marijuana on the weekends, not at the office or not at the workplace, and could still test positive during a drug test taking place during the work hours. So with respect to driving, I was just trying to kind of find what have other states, how do they determine what under the influence means? And with respect to driving, some states have defined driving under the influence. Washington, for instance, it's a THC concentration of 5 or higher, and that's shown by a blood analysis. A lot of states have these zero tolerance laws for marijuana impaired drivers, which just means if they have any amount of it in their system, they can take action. In Missouri, we have the legal limit for driving under the influence of alcohol, we all know is 0.08. But for drugs, there's no specific limit. Instead, any amount of drugs that impairs driving can be enough for a conviction. And that's tough for criminal defense lawyers and prosecutors to prove. How do you prove that it's impairing your driving? Again, you can test positive for up to 25 days. So that's another thing that the law is going to be wrestling with here. I think this is, Ruth, I think this one is yours, right?
Yes.
Maybe this is mine.
Okay, so the easiest way to do this, because there's no test, Missouri tried to pass a statute that said that you are considered to be under the influence if you flunk a test. but that didn't go through, and I don't know if it would work under the Constitution anyway. And that's what's really hard is the Constitution will trump state law. So the easiest way to do it is to have a chart that your supervisor puts together and checks off looking for behaviors. So here would be odors, the smell of marijuana, movements, unsteady, fidgety, dizzy, eyes, dilated, constricted, or watery eyes, flushed face, sweating, confused, or blank look, speech. That would show under the influence, and then getting a drug test would also bolster your case. But you can't just rely on the drug test anymore, at least until Missouri law has some, there's some Missouri law, but right now there's no Missouri law. So you're going to have to use a good chart like this, and then have the supervisor check it off, or a coworker, and then keep it in your file. Okay, next one. So Missouri Human Rights Act has, it sort of mimics the Americans with Disabilities Act. And there are rules whether or not you should ask someone if they have a disability, which basically you can't, but you can ask someone if they have COVID-19. So although the federal law provides no protection for marijuana use, especially in the employment setting, the Americans with Disabilities Act does not provide protection for illegal drug use, but now in Missouri, it's legal. And if you go through the cases, you'll see from other jurisdictions, there's all this discussion as to what's legal, what's illegal. Did the federal law preempt everything or just a tiny bit? So it gets really complicated. Does every qualifying patient with a ID card necessarily have a disability? It could be that it could be one of those fake physician certifications, and that's how they got it, and they don't have a disability. So if you have to tread very carefully. As you know, if there's a qualifying disability under the ADA or the Missouri Human Rights Act, you have to enter into the interactive dialogue and accommodate the employee. But if you enter into the interactive dialogue with the employee and the employee says, I need this, and you could say, okay, well, I know you have this card, but I need to know from your treating physician, especially if they got the card from, if they got a physician certification from some mill that's out there, as exactly what that means for your work. So you could inquire a little bit more. You could ask the doctor for more information, and you could ask the employee for permission to talk to the doctor. The Department of Transportation has their own rules, and you can't drug test. I mean, you cannot have any drugs in your body. So there is no way that you would be able to trump DOT or any of the rules. DOT has worked so hard to try to find, like Kate said, some sort of test that would show influence, and they're not there yet. So right now, if you're doing any kind of driving and you're covered by DOT, there would be no exception for medical marijuana. Okay, next one. So can I ask an employee if they're a medical marijuana user? You can't ask about disability. You can't ask about disabilities, but you can ask about COVID-19. So there's two ways to do that. You could, you know, as you hire someone, if you offer them a job, you can ask about disabilities. And the only other exception is the one there that the information is job related and necessary for the conduct of business. The best practice would be to have the employee come to you with the ID card and then work through the interactive dialogue with the employee. The ADA and the Missouri Human Rights Act says that you have to accommodate employees who are disabled, who can perform the essential functions of their job. So here, some employees could have performed the essential functions of the job. When I first read this constitutional amendment, I thought that if my employer said a forklift driving is pretty dangerous, you can kill someone or kill yourself, that would be a dangerous job, and therefore it would be automatically excluded. But reading the constitutional amendment, It still says even if you are working with a dangerous device, you still have to show under the influence. So it's tricky. It's just, the bottom line is if you do have an employer applicant who tests positive for marijuana, it's the beginning of the process. So I do a lot of employment law, and I have had no questions about this ID card. So my feeling is COVID-19 has taken over, and there's been a lot of layoffs, and this has not been an issue. There's no cases that we know of that are perking up. There's no explanation from a court as to what you should do. So you should slow down and go very slow, because you don't want to make law in Missouri. You would rather have somebody like Walmart make law in Missouri. So on to the next slide. The workers' compensation is another issue because it's a statute. And remember, constitutional amendments would trump a statute. Missouri law reduces benefits when an injured employee tests positive for drugs in violation of the Drug-Free Workplace Act. Now, I am sure there's going to be a situation where a supervisor did not fill out whether or not the employee was impaired or was under the influence, and the workers' comp lawyer that represents the employee is going to say, okay, prove it. And this statute in Missouri may be overturned. What's sort of interesting is that studies have shown that access to medical marijuana has been tied to a reduced number of workers' compensation claims. Medical marijuana is good for underlying psychiatric issues or just plain old anxiety. And people may have been taking it even when they're on temporary disability payments, may feel better about returning to work quicker. So that's sort of interesting. I don't know what's going to happen to that. I don't know how what cases or what kind of medical evidence a court will cite when it looks at whether or not the workers' compensation statute is valid under the Missouri Constitution Amendment for medical marijuana. Okay. So basically, don't create bad law and don't be Walmart. Walmart's decision was 20 pages long. So they spent a fortune on the case, and you don't want to spend a fortune on this issue with your employees. So draft, revise existing workplace policies regarding the use of medical marijuana. You can't just say this is a drug-free workplace. That's not going to work under the Missouri amendment. Identify whether you have contractual obligations that require you to maintain a zero tolerance policy. That would be government contracts. That would be working with maybe big pharma, which would require this kind of thing. But you'd have to look to see if what those government contracts say or what the contracts you have with customers and what you can do about it. But a lot of customers require drug testing. And the last thing is if you have a collective bargaining agreement, maybe negotiating this up front would be easier than going through a lot of arbitrations. So I think that's the best we can do right now, given that the law is very uncertain.
I think that, like Ruth mentioned, a lot of employers now are mostly concerned with keeping their employees, and most employees right now are concerned with keeping their jobs. So these issues aren't really cropping up right now. But like I said at the beginning of the presentation, these issues were really starting, to ramp up. The laws they're still new. We're trying to figure out how things are going to be interpreted by the courts. So don't be surprised if, within the next few months or year that these types of issues really start to crop up in big numbers. So we just want you guys to be aware of the situation and the possible problems you can find yourselves in. And if you have any questions, feel free to contact Ruth or I with if you need any other information, or if you want a copy of our presentation, we'd be happy to email it to you. If you want to email us, our contact information is on the screen. Thank you so much for attending today. Is there any other questions that we have today, Scott?
There is a question here. Let me bring it up on the screen. It's from one of our YouTube viewers. If a person received all of their information and has a card, can they begin to grow the plants now?
They have a cultivation crop, 6 plants.
Okay.
Right. If they're a cultivator, that's the story.
Yeah,
they have their medical marijuana card.
Yes. It says legalizes the personal cultivation of 6 marijuana plants by patients registered with the program.
Okay.
Right, up to 6 plants, right.
Yeah.
Is there any other questions that anyone might have? We'll give you a few seconds here to enter it into either the chat or the comments. All right. It doesn't appear that we have any additional questions. Again, if you do have questions, you could certainly send either Ruth or Katherine a direct email at their email address, and they'll be happy to respond to you as well. So with that said, thank you, Ruth, and thank you, Katherine, for once again speaking during one of our chamber universities. We appreciate all your knowledge and on this issue that is certainly a growing issue in Missouri, and certainly with a lot of Missouri businesses as well, as they try to figure out how they work with employees who maybe have a card or whatever. So thank you very much. We certainly appreciate it. So with that said, we want to quickly just touch on one thing. As many of you know, we have seen a rise in COVID-19 here in St. Charles County, and I wanted to pass along and let you know that the Chamber Board has taken a position on asking businesses and residents to wear masks. And so we're asking businesses to personally enforce a mask policy within their business and require that. We don't want to impact the economy and have to potentially shut down non-essential businesses like we had to do, or like was done earlier in the year. So please wear your mask, and that way we could all get through this together and hopefully come out stronger in the end. So thank you very much for joining us, and we will be doing more of these chamber universities going forward. We don't currently have any scheduled, but keep an eye out on the chamber's calendar at gstccc.com and watch for future seminars. So thank you for joining us. Have a good day. Bye.